Okay, well, good morning, everyone, and welcome to Wells Week 2024. My name is Lisa Dianandon, and I am a philanthropy advisor here with the Edmonton Community Foundation, and I'll be your host for today's webinar. So thanks to an amazing group of volunteer lawyers and tax professionals like our hosts, our speakers today, Wills Week has been able to offer 13 presentations, both in person and online. Today is the last day, but we are recording this session and all online sessions, and they will be available on our website in the next couple of weeks. Wills Week is designed to inspire and guide you in the proper preparation of your estate plans, which include not only a will to protect your family and your business and your assets, but also additional documents to help you during your lifetime should you temporarily or permanently lose your independence. Understanding the hardships and additional costs that occur when these estate documents are not in place correctly will help you to appreciate the value of getting professional help for you and your loved ones. Edmonton Community Foundation is pleased to provide Wills Week as an important resource for Alberta-based will and estate information. It unites our role as a trusted partner to help people create a legacy for their community. Our area of expertise is endowment funds, contributions that are invested and provide ongoing support to enhance our community during and after our lifetimes. To learn how these funds are affordable options and how they can help you save taxes, please visit our website at ecf.ca. In our work, we see a lot of wills and understand how powerful these documents can be. We want everyone to benefit from these Wills Week discussions, and understand how professionals can make your will more effective and accurate. If you have any questions during today's presentation, please type them into the Q&A box. We will monitor them and answer as many as we can get to. You should find the Q&A box at the bottom of your screen, and we will endeavor to answer as many questions, but note that they will be the general ones. So in the interest of your privacy and also time, we won't be able to get to very case-specific or information-sensitive questions. As I said, this presentation is being recorded, as have all of our online Wills Week presentations, and they will be available on our website at EC Foundation. If you have any information, feel free to reach out to me. My information is also on our website. So I would like, also before I forget, at the end of the webinar, there will be a survey, and it really does help us shape and form information and presentations for Wills Week to make it as valuable for you. So it's only a very short survey, and we would ask you to just take a few minutes and fill that out. It's incredibly valuable. Okay, well, I'd like to introduce our presenters for today. So we have two amazing presenters. Allison Bardwell practices in all aspects of trust and estate planning and estate administration. Her services to clients include creating estate plans, preparing applications for probate or administration, and advising personal representatives, trustees, and beneficiaries in contentious and non-contentious matters. For estate planning, Allison works with clients and carefully considers their personal situation and objectives. She provides advice to clients on how to best organize their affairs to ensure the unique wishes of each client are carried out. She enjoys working with the client and their advisors, which include financial advisors, accountants, and other professional advisors. When Allison's not in the office, you can find her on the golf course, running in the River Valley, or volunteering within the community. She currently is a board member of the Today Center and CEAN Edmonton chapter. In addition, she is on the Wills Week committee with the Edmonton Community Foundation, and she really enjoys presenting and educating the community on estate planning and estate administration matters, even when she's with her family over Thanksgiving long weekend.
What can go wrong?
Michael Simons. Mike carries on a busy practice in corporate and commercial matters, including corporate structuring, incorporations and reorganizations, business purchases and sales, new business startups, and mergers and acquisitions. Working with both business and agribusiness clients, Mike also helps families address business succession planning challenges, including intergenerational transfers of business and wealth. Mike enjoys working with clients in all areas of estate law, including grants of probate to allow for the proper administration of an estate. First-hand knowledge of the strains and stresses of this process helps Mike foster communication among parties seeking to address and resolve issues before they grow into conflict. When conflict is unavoidable, Mike applies his knowledge of estate law to estate dispute and litigation matters, including family maintenance and support claims. Mike is a proponent of proactive estate planning, from the preparation of straightforward wills and related trusts, enduring powers of attorney, personal directives, and enjoys working with other professional advisors to implement more complex tax plan strategies when needed. Mike deals extensively with clients working on the purchase and sale of both commercial and residential real estate and related financing. So without further ado, I will hand it over to Mike and Allison. Thank you so much for being here, and I will leave it with you.
Lisa, thank you so much. I feel badly. I think that's an old bio where I put in proponent of proactive estate planning just to trip up your predecessor with a whole bunch of those.
Oh, it's me, Matt.
Yeah, that's right. You did way better than Matt, though, so well done.
Yes, I think our bios are a little long, Mike. We might have
Yeah,
to.
we got to. I told her to just say Mike's just a guy that thinks he knows stuff. So, but Lisa, well done and welcome aboard. This is Lisa's first year with the Community Foundation, and they must have great faith in her, Allison, to stick her with the two of us.
I know, I feel bad for her. I think she's short straw.
Up for the challenge.
That's a nice background you got on your screen, Allison.
Thank you. I am spending Thanksgiving with my parents and my brother. I think the last time the four of us were together for Thanksgiving was 2007.
Wow.
What can go wrong? Family all together for the weekend?
Absolutely. Absolutely. There will be no feuds, I'm sure.
Sure. I'm just hoping that my mother doesn't undercook the turkey again this time.
Medium rare is the way most people like it. So
nothing like a little food poisoning for the airplane.
Absolutely. Absolutely. So here we go again, Allison. Let's see. We did Family Feud.
We did Jeopardy.
And now we're playing Name That Tune to the version of Name That Feud. And so the first thing I would like to do is give a big shout out to I used to say student, now I have to say colleague, Hadil Othman, who put together our PowerPoint presentation and for our Friday morning dance party. I told Hadil, whatever you do, just try and make me look good. And that's a big task. So
yes, amazing job. Thank you so much. Yes,
we'll see if the technology.
I had her last night and this morning, and she's making it all work. But if the technology goes wrong, it's all on us.
Absolutely, absolutely. So I know our sessions about talking about these somewhat famous feuds involving estates and estate planning. And I know there have been a lot of sessions this week on estate planning 101, et cetera. But as usual, do you think we should start off with just sort of defining the components of a typical estate plan and naming who the participants are, Allison?
Yes, I would. I think that's a good place to start because sometimes we think we think people know our lingo, but they don't know our lingo. So to make the game more fun, I think we should give the background or the rules of the game. Maybe.
So why don't you kick us off?
Okay, so when we talk about estate planning, everyone thinks we're just talking about a will. But when we talk about estate planning, we're talking about three documents. We are talking about a will. So the will is a document where it comes into effect when you die. Before you die, it's not in effect. And in the will, you name who you want to administer your estate. So that's the person that gets to pay all your bills and give out the money to the beneficiaries and deal with any disputes. So we call that the executor, or we will also use the word personal representative. It is the same person, it's just different lingo. We also have, I'll let you go into more detail. We can flip through each document in more detail after. We also have the enduring power of attorney. And the enduring power of attorney is the document that allows a person during your lifetime, either immediately upon signing of it or upon loss of capacity or a later date, to pay your bills, deal with your finances, deal with your investments, pay your taxes, deal with your property if you need to have your house sold, and then generally hold the money for your benefit until you pass away and your will comes into effect. The final document that we seem to find people seem to misdoing is the personal directive. And the personal directive is the document. It only comes into effect upon loss of capacity, and it allows the person appointed in the document called your agent to make healthcare decisions on your behalf and personal decisions. So decisions related to what sort of treatments you would receive, end of life decisions as to when life support should be withdrawn, if you're no longer able to live in your home and need to be moved to a long-term care facility, they get to choose the home. So choose wisely.
Yeah, that's a great summary, Allison. And although today our focus will be more on the will side, I often tell clients that in a lot of ways, the enduring power of attorney, where you appoint your attorney to handle your financial matters, and your personal directive, where you appoint your agent to make your medical decisions, are sometimes more important to people, or should be more important to people than the will, because they actually impact them during their lifetimes. Whereas a will is just a piece of paper until someone dies, and none of us know if you're going to know what happens afterwards with your will, but you're going to know what happens during the other two documents. So I think they're quite critical to have in place. When we're talking about wills, we often talk about an executor or a personal representative or a trustee. For our discussion today, those are relatively interchangeable terms. And then we're often talking about beneficiaries. Beneficiaries are someone that receives a gift under a will, a bequest, either a specific amount or a share of the residue or a piece of the pie, such that it is. And so I think that gives sort of the basic outline of the three-part estate plan. Anything else we need to add there, Allison?
No, we'll probably, if you do not, we should tell you, and as you will learn today, if you do not have a proper estate plan in place, I say you either pay the money on the front end or you pay a ton on the back end. And these estates, the only reason we know about these estates and what has happened is because there has been a lot of litigation. And litigation means that there's more than one lawyer involved. And this is costing the estate hundreds of thousands of dollars, maybe in the case of some of our more famous estates, millions and millions of dollars.
You bet. And so the other thing that we didn't mention within an estate plan is it gives you an opportunity to do some charitable giving. And Alice and I obviously feel pretty strongly about this. We've volunteered with the Community Foundation Wills Week for a year or two, I think, or 10. And so
That old Mike.
yeah, well, I am. And so that is quite critical because I once in a while get people saying, well, it doesn't matter if I have a will. My family knows what charities I want to benefit. And if you don't have a will and you die what's called intestate, or without a will, without an executor, without designated beneficiaries, there's typically a set of default rules that will fall into place. And those default rules do not allow for charitable giving.
Yes. It's also, one more thing about charitable giving. You hear the word estate tax. We don't have a state tax per se in Canada, but upon death, it is deemed that you have sold your entire estate the moment before you die at fair market value. So that is a taxable event. And charitable giving in your will can offset the money you might be paying to our friends in Ottawa. It will offset, but it's also working with a lawyer who practices in the area of wills and estates, who can give you the appropriate advice so that maybe you can put your estate in a better position so that you can give the beneficiaries more and the charities more.
Great comment. So without further ado, but probably with a fair amount of technical glitches, I am going to share my screen. Let's see if this works.
And thank you everyone for joining us today.
Yes.
Mike and I have a really good time doing these presentations, and we're happy that people actually want to come watch us.
You bet. All right. Can you see my screen, everyone? Perfect. And let's see. Name that feud.
Are you piano today, Mike, in the background?
What's that?
Are you going to be playing the piano?
No. No, I'm not. We're having a dance party.
Okay.
And, so here's the way this is going to work, Allison. I'm going to hopefully click properly on the presentation. That'll start some music. And when you have a guess as to the music and or what feud that music's referring to, you just feel free to yell it out, okay?
Just yell it out.
Just yell it out, and then tell me when I've just say, Mike, enough with the music, and I'll figure out how to stop playing the music. So let's see if I can make this work. Allison, you don't want to get stuck in a place where you make the quickest estate plan.
Don't need my life to move any faster than a Chevy on a 2-lane road. Stuck behind a tractor. Stuck behind a tractor. I miss the quiet. I miss the stars. My old
This is one of our most famous estates in Canada, because this is the estate of Cecil George Harris.
Well guessed, Allison. Well guessed. Yes, this is every law student learns about this estate in Canada, because the poor fellow Cecil George Harris got trapped under his tractor, and he didn't have a will. So if you got trapped under a tractor, Allison, first of all, I'd question why you were there, but and I'm sure you have a current will.
Yeah.
But if you didn't, what in the world could you do?
Mike, I think I could take whatever tools I had, or if it's even my finger, and try and scratch a will into the fender of my tractor.
And that's exactly what Cecil George Harris did. He got pinned underneath his tractor in Saskatchewan, took out his pocket knife, and wrote a will that said, in case I die in this mess, I leave all to wife Cecil Geo Harris. And Allison, I've never been there. Have you ever been to the University of Saskatchewan Law School?
No, we should take a road trip. Maybe we could go there next year.
Absolutely. So they're in the law library at the University of Saskatchewan. They have that fender mounted up on a display with the will. Look at that. Look at Lisa's face. She didn't know that part. They have that fender mounted up on a display, and the court found that to be a valid holographic will. Now, Allison, what is a holographic will?
A holographic will is a will completely in the person's handwriting or printing. So it means that it's all been written by them in pen on a piece of paper. It's not electronic yet, but we might be going there one day, right, Mike?
Yeah, BC has electronic wills or electronic signing of wills. Alberta does not.
Yes.
But yes, if you write a will all in your own name, all in your own handwriting. Now, the law, strictly speaking, in Alberta is dated at the top and signed at the bottom. But one of the most unique elements of a holographic will is that you have no witnesses. The fact that it's in your own handwriting means that the court will accept that it is your will. That's why You shouldn't download a will kit. I know, Allison, you're a big fan of will kits, but downloading a will kit and filling it in does not count.
Yes.
And so every once in a while, I'll get a call from somebody, a little less so as I get older, but when I was a bit younger and friends had young kids and they were leaving the kids with the grandparents to go to Mexico for a week, and they never did get around to doing their estate plan, and they'd call me at 10 o'clock at night saying, "We got to head to the airport at 4 a.m. What should we do?" First, after I stopped swearing at them, I would say, get a piece of paper. And I said, "Okay, I've got my computer." I said, "No, put your computer away, get a piece of paper, get a pen, and here's what you do. Get a fender of a tractor and get out
And
your penknife." Yeah.
yes, just to comment on this will, obviously it had to go to the courts for the courts to find it to be valid. There would have been other issues with this will if Cecil had a previous will, because the first line in all wills, generally, if they are properly written, it says, "I revoke all previous wills and codicils." So codicils are an amendment to the will, which we'll need to know about for a later name that tune game. And this means that it's revoking all. So if Cecil had had another will, we would have had to read them together potentially, and that would have created a bigger mess. Instead, his fender will stay in the University of Saskatchewan's law school library forever. So if
It's an interesting story. Have you read? It was, I mean, interesting in a most morbid, horrific way, because he didn't die under the tractor. They were able to get him out into the hospital, and he died the next day. But he was, and in the middle of trying to rescue him, there was a huge thunderstorm, and the field turned to mud. They had to get other tractors to pull him out in a car that was stuck in the mud. It's it was a figurative and literal mess.
Stuck in the mud trying to tow one another out.
Yes, exactly.
Song came from, Mike?
Pardon me?
That where maybe that song came from? There is a
Yeah, stuck behind a tractor. Absolutely. Well, I don't know about that, but all right. Well played, Allison. But I got some tougher ones for you now.
Uh-oh.
Yeah. Let's see if you can get this one.
Mike, where are you making
I'm loving it.
Okay, this is the McDonald's song,
Yeah.
and the song is "I'm Loving It."
Well, you guessed the song right, but what does McDonald's have to do with Will's Week?
Oh, this is another famous Canadian case. And there was a gentleman in McDonald's who thought he was having a heart attack. Named
Imagine that, a heart attack from McDonald's.
Shocking. And he thought he was having a heart attack, so he wrote a will on a napkin. And we've all heard about the napkin wills.
Back of a napkin, that's where the best things happen, right?
They're told, right?
Yeah, and poor Philip Langan, he died in 2015, and two of his children came forward with a McDonald's napkin, those distinctive McDonald's napkins, claiming that was his will, and that he made it when he thought he was having a heart attack at McDonald's. Why do I feel like this probably wasn't the first time someone wrote a will on a McDonald's napkin thinking they were having a heart attack there?
I don't. Why would anyone do that, Mike?
I don't know. And now here's the interesting part, Allison. The court found this to be a valid holographic will with large fries, they said.
Oh, that's funny.
Yeah, thank you. And so there's an interesting point to this, though. if he had just been scribbling on the back of a napkin, the court wasn't sure that that would be a valid holographic will, but they have to make sure that whatever the note is done with what they called a testamentary intent. You want to explain what that is, Allison?
Testamentary intent means that the person writing the document understood what they were making a will, and in it, they were giving away all of their assets.
Gotcha. Well, he probably had a pretty sizable estate if he was only eating at McDonald's. So, although not anymore, it's pretty expensive from what I hear.
Yes. Well, my brother was telling me this morning how much he likes the fillet of fish and asked if I wanted to go for lunch. I was like, no.
I've never been a filet of fish guy, gotta say.
Me neither.
I miss the McDLT, where they have the hot side hot and the cold side. You're probably too young to know that, but
Thanks, Mike.
you're welcome. So this is two different cases where, although I gotta say, I think the tractor case was much more dramatic, scratching it on a fender versus scribbling it on a McDonald's napkin. And what I think is really interesting here is that my understanding is that he didn't die in that McDonald's, have a heart attack, but when he did die, his daughter had kept that napkin.
Wouldn't you keep it?
Well, if you look in the door of my truck, there might be a few old McDonald's napkins, but they don't have a will on them. So,
Okay.
yeah, it's you and I had recorded that podcast, and one of the snippets out of it I was listening to was, there's no such thing as a just-in-time will. You're typically too early or too late. And in both these cases, well, I guess the tractor one might have been a just-in-time, although it's not probably the way you want to do it. But this one, you would think after someone thought they were having a heart attack at McDonald's and didn't, that they would then scribbled on a napkin that they would go and do an estate plan.
You never know.
Oh no, I do know. I do know. Death and taxes.
Death and taxes. Unfortunately, estate planning, as we know in our business, that some people, death unfortunately is a certainty for all of us. We don't know when. None of us have a crystal ball. So it's important to have these documents in place. Yes, Mike and I are laughing at these cases, but unfortunately, thousands of dollars were probably spent on legal fees, and that means that everyone is receiving less in the estate potentially. And it's a case that we talk about because it was a case of bad estate planning, and unfortunately, scribbling your will on a napkin is not a good idea in most situations. Mike, actually, I just ended up getting a grant of probate. A grant of probate means the person had a will, and the lady had written her will in her writing, so it was a holograph will. And then she used the back side of the paper as scrap paper so she could write down her account numbers and add them up.
Yes.
And she did her will in blue pen and dated. And then she took a black pen and crossed off things on the will.
Oh,
and that was her codicil. So the codicil was the amendment to the will.
oh boy.
I ended up getting a grant, but I had to send it to another senior practitioner in our area. And she was like, I don't think you can get a grant on this. So I sent it to her. I was like, miracles happen. But
challenge accepted, eh?
And unfortunately, to get the grant, we had to spend a lot of time going through each piece, each paragraph. With these types of wills, you think the person doesn't know what they don't know. And sometimes when they give gifts or bequests in the will, it is too general. And so then we have to spend a bunch of time as lawyers speaking to the executors or personal representatives to try and figure out what the person who wrote this will was trying to say.
Yeah, it's I mean there's now it sounds a bit self-serving because we are wills and estates lawyers to say, you know, there's good value in hiring a wills and estates lawyer, but truthfully there is. It's much like, you know, when I need something fixed, if I need a plumber, I don't hire a carpenter. And so I think there is a good reason to get people that understand the complexities of this area, because while a lot of people see things as fairly straightforward, you and I both know that there are more complexities to estates than people can realize. Things that flow inside an estate, things that flow outside of an estate by way of survivorship, and the planning related to those things can be quite critical when dealing with an estate plan.
Yes.
All right. I think I got a tough one for you here, Allison.
So Mike, our Canadian content, I'm guessing. Now we're going on to the US content.
We're going on a trip south.
Mike, I was enjoying the song.
So she was the queen of soul.
Yes.
She was the queen of problematic wills.
Aretha Franklin.
Yes.
Amazing
Yes.
singer. But not so great with her estate planning. Why do you think she wasn't so great with her estate planning, Mike?
Well, you know, she probably thought her estate was just a small, simple, estate, and she probably didn't need to have, you know, lawyers are expensive, Allison. And
Yeah.
if you've only got an estate of $80 million US, you probably don't want to spend, you know, a few $1,000s dealing with a lawyer.
Probably. And, you know, people live forever.
Absolutely. And yes, poor Aretha, this is only 2018 when she passed, and an $80 million estate. There wasn't one will, there wasn't two wills, there were three handwritten wills found in her home.
So when you're looking at wills, again, we would have to look at the wording to say, I revoke all previous wills and codicils, because that would revoke the previous one as soon as you sign the new one. But you also have to look at the dates to see when the dates of the wills were signed. You would have to look at the contents to see if there was the testamentary intent that this was to be their will and they were disposing of their assets. And in Aretha's case, they found the 4 wills, and I think, was it they found the one under the sofa?
I think it was under the cushion of the sofa, which is typically what I advise my clients. You know, here's a copy of your will. The best place to keep that is under a cushion of your sofa. So
Yeah.
That's in your reporting letter too, I think, right?
Yeah. But under the cushion of your sofa, it is the safest place.
Yeah, it's I mean, that's why we're talking about it today. You have these people that have lived an incredible life, have amassed significant wealth, and I have to tell you, it boggles my mind. I am, as I made Lisa say, a proponent of proactive estate planning. I can say it myself. But I am. I have clients and friends and people I meet on the street. Well, maybe not quite that much, but I am a big believer and sometimes can be a little pushy about getting people to do their estate plans, because I don't want to be the lawyer where someone says, well, Mike, you were their lawyer. Surely you spoke to them about doing some estate planning. Well, it never came up, you know. So it just boggles my mind that these people can have this kind of wealth, obviously have managers and professionals in their lives, but never get an estate plan properly done.
Yes. And to hide it under the cushion of a sofa, very
File it.
file it. You call it filing.
Yes.
Maybe she got busy and she just put it away and was going to come back to it later.
Probably. It is really shocking to me. But yeah, and it's unfortunate because as you know, Allison, once an estate goes to litigation, everyone's lost. I mean, the cost of litigation is very high, and the results of litigation, I often joke with people that, a judge's job is to make all sides equally unhappy. And so I've rarely seen an estate go to court in a dispute where even the winning side feels particularly satisfied.
Right. No, I agree. It's unfortunate. And yes, you would think that someone like Aretha Franklin would have the proper estate planning documents in place. As a side note, just because she had so many wills, I don't know what your practice is, Mike, but I tell my clients to take a look at their estate planning documents every 3 to 5 years or after any significant events in their life. And significant events could be a relationship breakdown, birth of a child, death of a family member, and just to review the documents to ensure that they still make sense. As lawyers, I know we are super paranoid creatures and we always have backups in place. So if life does change, you just have to see if the backup still works.
Yeah, no, that's a great comment. Allison, I noticed a question in the Q&A about when someone dies without a will and whether their estate needs to be probated. And generally speaking, the answer to that, in my opinion, is it depends. And often what it depends, and we touched on it briefly, is how the assets of someone's estate are held. So, for example, my wife and I have everything we own jointly with the right of survivorship. So if one morning I can't push the pillow off my face, then everything flows to her by operation of law. Our house is held as joint tenants. Our bank accounts are joint with the right of survivorship. So there's a likelihood that, and I do have a current will, but even if I didn't, there's a likelihood that my estate would not have to go to probate because everything is set up to flow to my wife.
Right. So, Mike, actually, I have had estates recently where it's husband and wife, and one of the spouses has passed away, and everything was joint, but then with registered accounts being the tax-free savings account and the RRSPs, the spouse was named as the beneficiary of the accounts, but the financial institution still wanted a grant of probate before they rolled it over.
Really?
Yes. I've had 2 in the last year, which
banks. Banks. Now, the other interesting part of that, of course, is dealing with Canada Revenue Agency. So being able to deal with CRA, a grant of probate is very convincing for CRA to know that they are dealing with the right person. Absent a grant of probate or a grant of administration, if there's no will, those are the 2 parallel processes. CRA generally will accept a surviving spouse to act on behalf of an unprobated estate. But I have run into situations where in more complex reporting, like an accountant dealing with these things has run into a situation where CRA wants wants a grant of probate in order to know who they're legally entitled to deal with.
Right. Okay.
Yes.
I think it's time.
Okay.
I'm ready for the continuation of our dance party.
I don't think you're going to get this next one here. Let me see if I can make it. There. Oh, no. Hang on. There we go.
What have I got to lose? Honey, I say, big red Corvette. Baby, you're much too fast. Big red Corvette. You need a love that's gonna last. Guess I should have closed my eyes when you drove me to the place where you.
Okay. So it was at one time the artist formerly known as Prince, but when he died, he was Prince. Do you have a real name?
Prince. He's one of those iconic people that only had to have one name. I think his name, at one time I knew his real name.
I did.
I might not look like a Prince fan, but I am. I was bragging to the two of you before we started that in my youth backpacking across Europe, Prince was playing a live concert in Rome, and my two cousins and I were able to get tickets and go and see him live in concert in a stadium, which was pretty incredible.
That would have been amazing.
It was pretty awesome.
I wish.
Yeah. But as an amazing of an artist he was, he, I think, was one of those people that just could not contemplate the fact that he was not going to live forever and died without a will. I find this staggering. $150 million estate in 2016.
And a 6-year legal battle. What do you think that meant in terms of fees?
It was probably very efficient and frugal. Yeah, it's and of course he also had a complex family life. I think he had 6 half siblings, and so if there was a Mrs. Prince at the time of his death, maybe that would have worked better. Sometimes the default rules favor people who are in marriages or have recognized by them children. I don't know if they're legitimate is even a legal term anymore. In the old days, it was, legitimate heirs. People aren't so concerned about that anymore. The law isn't as concerned about that anymore, which is good. But 6 half siblings were declared his legal heirs.
Crazy. But then they weren't able to reach an agreement and ended up in court.
Yeah, as recent as January of this year, there was litigation ongoing about breaches of his trust from his estate, and the ridiculous legal battles. As a matter of fact, I think I read somewhere that there's a catalog of unpublished songs that he recorded, and I think in his estate and also in Michael Jackson's estate, where they were there's all these songs that and there's controversy about whether they haven't been released because of this or they haven't been released because the state didn't think that they wanted them released. It would be great to know what their intentions were. Imagine that.
I'm wondering, obviously, Mike and I did not do the deep dive onto the legal decisions. We were more the overview on the published articles in newspapers and different magazines. So we did not do the deep dive. But I would be curious, Mike, because there were the 6 half siblings who were declared the legal heirs. I wonder, because in Alberta, if you die without a will, we look at who has the first right to apply And in this case, if it was the half siblings were the heirs, in Alberta, all 6 would have a right to apply to be the executors or personal representatives of the estate. Administrators, because there was no will. So if you're having 6 people who are trying to administer an estate, they need to be unanimous in all decisions. How do you think that will go?
Wow. Yeah, that probably isn't going to happen. And in Alberta, I mean, the default rules on an intestacy would be to a spouse, if not a spouse, to children, if not children, to parents, if not parents, to siblings. And I don't know if I've run into an estate where there was an intestacy and there were no full siblings, but only half siblings. Have you, Allison?
I have not, but Mike, this past few years, I administered an estate for a person who died. He had never been married. He had no children. He was an only child. And he
Wow.
died in his late 70s. So we had to look, obviously, it would have gone to his parents, but the parents had passed away. So then we looked to his grandparents. They had obviously passed away. And then we had to go down and look at aunts and uncles. And most of them had passed away. So then we had to move down to first cousins on both sides of the family.
Wow. That's crazy.
And he didn't keep in touch with lots of his first cousins. And so they didn't actually know him, but they were receiving a windfall, per se.
Yeah, and I know I faced challenges even finding people. I've had to hire private investigators, and everyone says, well, surely there's a registry where you can just see if someone's died. And it's, well, it's not as simple as that. Yeah, it's and of that generation, I mean, one of the private investigators I dealt with is very good, but they rely tremendously on the internet. Well, if
Right.
you're trying to find someone in their 80s, they might not have an internet profile. And so it can be very challenging.
Yes, no, this was very challenging. Fortunately, the personal representatives of the estate ended up being fascinated by the family tree on the opposite side of the family and spent probably 100 hours going deep and trying to figure it out, going through letters and address books and contacting, and we were able to locate the beneficiaries, but very messy.
That's crazy. There's a question in the chat about beneficiaries requiring executors to provide accounting of an estate. That's a very interesting question on what levels of accounting are required for an executor. I mean, obviously here we're talking about an intestacy, but even in that case, someone has to administer the estate. Can you imagine doing an accounting on $150 million 6-year legal battle estate? That would be fun, right?
Right. Well, and the court would probably have to decide where the fees are coming from. So the court actually may decide that some of the fees are to be paid from Prince's estate, since he's might be the reason why everyone is in court, since he died without a will. So it's an error on his part. But the court could also decide that maybe some of the beneficiaries were very litigious and were unreasonable, and that they have to pay their own legal fees. So it's an interesting battle. And if they found the personal representative who was administering the estate unreasonable, then they might be responsible for some of the fees. I'm sure Prince had it all in one account, right?
Oh, yeah, probably just in his local credit union or savings and loan. That's a strange thing about the United States. There are so many banks.
Yes.
Thousands and thousands.
So for the accounting, the personal representative has to take the value of the assets as of the date of death, and they need to do a complete accounting from the date of death to the date of distribution. So depending on So all money in, all money out, and they need to account for every transaction. They do need to keep receipts because the beneficiaries can ask for receipts. And then at the time of distribution of the estate, meaning that the personal representative is giving the beneficiaries money, the beneficiaries get to review the complete accounting. They get to approve it. And usually, well, always, we ask them to sign a release saying they approved everything that the personal representative has done and they are not going to sue them, and that they accept their distribution and the accounting as is.
Now, I will say though, while I tell my clients to keep all the receipts,
They don't.
my experience is that the courts are reticent, unless there are signs that the executor has done something improper. When I've gone to court, a court has said, no, the executor does not have to provide a receipt for every penny and dollar if the informal accounting is reasonable. I have had estates where, a beneficiary says, I want to see the receipts for all of the expenses. I want to see the utility bills if the house is there, et cetera, et cetera. And the court said, no, the cost of what is essentially a forensic accounting. As a matter of fact, one time I was in court and the court said, that's fine. If you, beneficiary, want to pay for the forensic accounting up front, that's fine. And if you find a material problem in the accounting that was provided, then I will consider whether the estate should pay for some of that accounting work. But a forensic accounting on an estate can be tens of thousands of dollars. And so in probably 95% of the files I have, it's just an informal accounting.
Yes. Okay, Mike, let's play.
Oh man, you are a gamer, I tell you.
I like
All right. Let's see. Oh, come on, technology. Don't fail me now. Oh, the king.
When you don't believe a word I say, we can't go on together with suspicious minds, and we can build our dreams on suspicious minds. So if an old friend I know.
Okay, what a
I'm
great
enjoying our chat, but I'm almost enjoying the music more. I feel badly turning it off.
I know. So I know we had the king who died tragically, but we also had Lisa Marie Presley.
Yeah.
And I think it's time for your favorite quote from law school from Professor Hop.
Silence equals suspicion, Mr. Simons.
And the estate of Lisa Marie Presley, we've seen it in the news because of her tragic death. So in this case, her mother, Priscilla Presley, contested her daughter's will, claiming that the amendment to it was invalid.
Forged, in fact, and that her signature didn't match her writing style. Have you ever dealt with an alleged forgery, Allison?
I've had to deal with handwriting just because of the holographic will, or we've been unable to locate the witnesses to the will, but I've never had to deal with a forgery. Have you?
I did once. There was a fellow, an ex-RCMP handwriting specialist who lived in, I want to say Medicine Hat or Lethbridge. I sometimes mix those two up. I think his first name was Les something. And he was a handwriting analyst expert, and you would send him the documents and he would look at them. He also was an expert at ink analysis, so you could look at the style of ink and how it was on the paper to tell how old the signature was. It was now he might have just been making it all up. I don't know, but it was fascinating. It was absolutely fascinating to deal with.
So here is another extremely this estate, I don't even know what the assets are because she had most of Elvis's assets. So she had made an amendment without any witnesses.
Wow.
So
Wow.
here's a person who probably has access to the best legal teams and thought, I don't really need anyone to do this. And it led to litigation. I wonder how the family's getting along now.
Yeah, that's a troubled family, unfortunately, and it's so sad to see. And I know there's also been some other news about, I think Graceland was going into foreclosure at one point, and Elvis's trust was being challenged. Which means I think the next time, instead of the University of Saskatchewan, maybe we should be doing this from Graceland next time.
For us to go.
Yeah, for sure. I'm sure there's a benefactor out there that would like us to do an episode from Graceland. But yeah, it's sad to see, and you've probably seen it while you were just talking about it, people that take their valid wills and then start scribbling on them and trying to do amendments in handwriting, which is just a hot mess to deal with in an estate, right?
Yes. So this settled, but again, the fact that it went to litigation, I do wonder what Priscilla's relationship is with Riley now.
Yeah, it's probably very challenging and very sad, right? Because I've had estates where there have been battles brewing, and where I've been able to get all of the potential battlers together. And one of the things I have found is that when someone dies, and often when there's children involved, the money doesn't help, the family helps.
Right.
And I've been able to stop a dispute before it really got started, on the basis that it was more important for the family to take care of each other than to fight over the money. I'd like to say that happens all the time, but unfortunately that's the exception, not the rule. But I just this one estate I had where parents were tragically killed and children were left behind to be raised by family members, and there was going to be a fight about money. And that's when I realized, and everyone came to realize, that these children needed their family more than they needed people fighting over money.
Right.
So that was one of my rare wins, Allison. But unfortunately, in this case, Riley and Benjamin, Benjamin, of course, passed. But Riley and Priscilla probably did not have a great relationship afterwards.
Yes. And I guess one of the best gifts you can give your family is to do proper estate planning so that they can continue to get along after you're not here. And again, this was an example of bad estate planning, and it's showing the family possibly breaking apart. I don't know what the relationship's like. Hopefully they've been able to mend fences and get together, and hopefully they will be together for American Thanksgiving, since we're having Canadian Thanksgiving this weekend.
Yes. That's a long ways off. That's the start of their Christmas season,
Yes, I know.
Yes. All right.
Okay.
I'm going easy on you so far.
Oh.
Let's see. Now we'll see how sad.
They say we're young and we don't know. Won't find out till we grow. Well, I don't know if all that's true, 'cause you got me, baby, I got you. Hey. I got you, babe, you, babe.
Being married is not an estate plan.
It's not?
No, the tragic estate of Sonny Bono. Do you remember how he died?
He died in a car accident, right?
No, he was skiing. Very
Oh,
good, Lisa.
skiing.
He was skiing, and I think he skied into a tree.
Right. He lived
Yeah.
in Palm Springs. People have seen the mayor of Palm Springs.
I think no, yeah, maybe, or was that Clint? No, Clint Eastwood was somewhere else.
He's,
Uh,
I think he was the mayor, but he was the mayor of Palm Springs or something.
yeah, but he wasn't skiing in Palm Springs, but he died skiing on sadly, and had a bunch of different businesses and had no estate plan.
But he was married.
He was married. He was married to Mary, sorry, and but she had to petition to be appointed the executor. So
We don't,
maybe talk,
we,
sorry,
I said we don't really know California law, so we'll just
smile and nod about that. Yeah,
make
but
sense to us.
Allison, previously you talked about sort of those default rules, or I talked about the default rules for beneficiaries, but what about to serve as an executor?
So in Alberta, Mary would have had the first right to apply to be the personal representative of the estate. I don't know how many times Sonny was married. Do you?
Well, I'm guessing lots, but it's California.
Right. So his estate was worth $2 million. So it's not compared to Prince or Aretha Franklin, not a huge estate. So she had to petition to be the executor. And then guess what? A love
What?
child comes out of the woodwork.
Of course one did.
Sean
Wow.
Nachu claiming to be Sonny Bono's love child.
Oh, that's and this estate battle went on for 25 years. And now I'm going to say something that's maybe a little bit unseemly, but if his estate was worth 20 million or 200 million, a 25-year battle, there would be lots of money there to battle over and lots of money to pay for the battle. But I've had files like this with a $2 million estate where the battle went on for 10 years. And the tragic, so the first tragic part about it is, and nobody likes to do this, but it's the dead person's fault. They're the ones that left this mess, and nobody wants to blame somebody who's died, but they're the ones that left a horrible mess behind without a will. And then you have this 10-year or 25-year fight. A 25-year court battle will eat up $2 million.
I would say they're out of their own pocket at this point.
Right. And so it sounds horrible to say if you've got a huge estate, it's worth fighting over, but at least there'll be something left once the fight's done.
Right. So Mike, in Alberta, if Sonny had died without a will, he's obviously on his second, third, fourth, fifth wife at the time of death. He had children from previous marriages. So without a will in Alberta, Mary would have had the first right to apply since they were legally married at the time of his death. But the estate in Alberta under our intestacy rules, meaning he didn't have a will, would be Mary would receive the greater of $150,000 or 50% of the estate, and the remainder would be divided amongst the children.
That's right. It's intestacy, so it works well if you have one marriage and only children from that marriage. Well might be an overstatement, but but the default rules are generally similar to what a standard estate plan would be. So again, using my family as an example, if I'm gone and I don't have a will, everything's going to go to my wife, and we only have one child, and so everything will then flow to him. The default rules are okay. They'll work pretty much as our plan would. But when you've got multiple marriages and blended families and children from previous relationships, all of a sudden that can make for a crippling circumstance for a surviving spouse. And Allison, as you know, sometimes people will be common law with marry, but not married to marry, still married to share. But they never got it. Now, that's not the case here, but if he was still married to share, and if he was still married to share, but was living with Mary in Alberta, that's a whole other ball of wax.
That's a bad law school exam. We shouldn't
Absolutely.
go today. I know
Absolutely.
lives are more complicated because sometimes people are living common law with someone and they are still married because they did not finish they divided the property but didn't actually get divorced.
No, absolutely. All right. We're getting close time wise, and we're in the home stretch.
Okay. I
Let's
think,
see here.
oh,
This is an easy one. You should be able to get it without even the music.
but I like the music.
No one told you life was gonna be
Ready?
this way. Your job's a joke, you broke. Your love life's the old way. It's like you're always stuck in second gear.
This was a sad one. This one hit me hard.
This was a sad one. They're all sad. This is unfortunately the estate of Matthew Perry.
Yeah, good old Chandler Bing.
Yes.
Uh, tragic life, tragic death. Such a talent, and a really big estate, $120 million estate with $20 million a year coming in from residuals from his time with Friends.
Wow.
And no estate plan, Allison.
But they did find a will.
Was it a current will?
He had a will he executed in 2009.
Yeah, 2009. So 15 years ago.
Oh, and his situation changed.
Just a little bit. He had a plan. Wasn't a horrible plan. But at the time he made that will in 2009, he had a girlfriend, was with her for 2 years, put her in his will. And 15 years later, shockingly, they had broken up. And she is going to get a significant windfall from his estate plan.
Right. Yes, because she's going to be receiving a fifth.
Yeah. So a fifth of those residuals. It's I mean, I suppose I can't imagine. Now, I will tell you, Allison, I've had files where people have fallen out of relationships and had outdated wills, and I've talked to them time after time after time about updating their wills, and they are very good at avoiding me. And common theme in my life.
Maybe it's you, Mike.
Maybe, but I had a recent file where I think the person actually wanted the estate to go to the place he had in a very old will. And despite everyone asking him to update his will, he didn't. And I think it was intentional. So, I would like to think that Matthew Perry thought, no, she was the one good light in my life, and I want to keep her in my will. But I struggled to that would be reading very closely between the lines.
Yes, and his death was so tragic that you wouldn't expect him to die at the age of 54 under those circumstances.
No, but he did have quite a troubled life. This sounds a little bit gossipy, but I did see a news story. So his stepfather is the fairly famous broadcaster Keith Morrison, who's a Canadian broadcaster who made great fame in the United States as an anchor man, and he was quite close with him. And he is, my understanding is pushing hard for the criminal investigation and criminal charges to his death, because people working for him helped facilitate him overdosing, was my understanding.
That is my understanding as well. This is, again, this could potentially be a case where life has changed and he did not take a look at his estate planning documents to update them to deal with his new wishes as the girlfriend was gone. In Alberta, if he had been married to his girlfriend and then they divorced and he did not update his will, she would have been deemed to have predeceased him, because our rules say upon divorce that the person is now automatically taken out of the will unless you do a new will and put them back in. And this would have given a very different result, because the estate would have been split differently. She would have been taken out, so she would not be receiving the residuals or a share of the $120 million estate.
That's a great point, and it is a bit of a strange one, that the fact that they weren't married and divorced, but were boyfriend and girlfriend and broke up, does not disqualify her gift. It's interesting that you could be more committed to somebody and break up with them and the gift's disqualified, versus less committed to somebody, break up with them, and the gift is still valid.
Interesting.
Yeah, it almost makes you think that people should update their estate plans every once in a while, right?
Let's, again, take a look at every 3 to 5 years or after any significant events in your life.
I think that's a sound idea, Allison. You come up with some great ideas. Now, and to be fair, name that feud was your idea. I want to give Allison full credit here. We've sort of come to the end of the game. I think I've got one final piece of music.
That's a great song to end on, I think.
Well, again, full credit to Allison and Hadil. Allison was coming up with lots of songs. My song choices might have been as funny but less appropriate. So
Fair enough.
I think I suggested Dirty Deeds Done Dirt Cheap, but
Good.
So there's 2 questions left, and we haven't addressed them yet because I didn't think they fit into any of the examples. But one of them was what are the risks to beneficiaries in the estate if the POAs and ultimately the same executor choose to hire and pay a care provider, but did not provide payroll or T4s to the CRA?
that's I'm going to say that's an excellent question for an accountant.
Accountant, yeah.
But what I will say, and it actually leads to an interesting issue and something people aren't aware of. When you're acting as an attorney under a enduring power of attorney, or acting as the personal representative or executor of an estate, if you don't conduct the affairs of that person or that estate properly, you wear personal liability for that.
Yes.
And so, sometimes you see people trying to DIY it. I don't need to hire a lawyer. I can figure out how to get probate, et cetera, et cetera. And they don't realize, one of the first things I do when I get a call from somebody on an estate is I ask them who their accountant is, or who the accountant for the deceased was. Getting professional advice helps protect the person whose job it is who's taking on, it's not an honor, it's a burden to act as an executor. And getting proper advice that is paid for by the estate is, in my opinion, a prudent step for anyone filling those roles. Allison, thoughts?
Yes, it's usually costs the estate more if you do not get the advice at the beginning. Even just, I know with specific bequests and wills, if there's a specific bequest in a will going to a charity, it's getting the advice that maybe it's best to donate securities to the charity rather than cashing in the investment, paying the tax, and then donating.
Yeah, no, great point.
There's
Um,
getting advice from the beginning, because usually when we get the advice or we're being contacted afterwards and the estate is already being partially administered, sometimes we have a bit of a cleanup, and unfortunately it costs more money in legal fees to clean up than to do it correctly from the start.
Yeah, I often use a lot of cliches.
You do.
I do. But there's that one that says an ounce of prevention is better than a pound of cure. And when it comes to estate planning and estate administration, that is so very, very true.
Yeah. I've had, just in my time here, and also before I was here, I was on the charitable side of things. But having people say, well, I talked to my financial advisor, and I kind of feel like there's a bit of that's where you want to start, like have a look at what's in your lifetime. And in that estate plan almost starts with looking at your big picture, right? Before you get to your lawyer, make sure everybody else is aware of what's happening in your life, including your family. I think it's a big thing. Like my father, who died 10 years ago, was very organized, had everything. He paid his funeral, picked out the flowers for his memorial, and all the bits. But it would have been nice to sit down with him when he was doing it and just say, like, what do you want, Dad? What's happening, and how do you want me to do these things? So as an executor, because that's what I learned from Wills Week. The first time I ever attended one a few years ago was that, oh, that executor thing is a pretty big deal.
Yeah, it's
Complicated.
I often joke, pick the person you like the most or the least, because it's a lousy job. And I once had a lovely client, a little old German lady who was so incredibly organized, and she had me at her senior's home once, and she said, "Come here, see this? This is my death book. When I die, you get this book, and this has a list of everyone and like she was the most, and it. I was taken aback when she did that, because it was quite quite blunt, but it was incredibly helpful, right? She had everything organized, everything in one place, who was going to call her brother in Germany when she died, et cetera, et cetera. And that, as Allison said, doing an estate plan and being that organized, it's one of the greatest gifts you can give to your family members, because at a pretty lousy time in their life, hopefully it's lousy if you've died and they're sad, to give them that gift of not having to worry about all those things is pretty incredible.
Yes, I completely agree. It's also, as you mentioned, Lisa, to have the discussion with family members. I have had clients come in and bring their children, and we've gone through the estate planning documents so that the family can have an open dialogue. Because sometimes there's something in a document and it may cause hard feelings, and you can't fix it after you're dead or incapacitated. So the goal is to try and keep the family together. The goal is to have the open discussions. Thanksgiving is the perfect time with your mother's undercooked turkey or overcooked turkey. As maybe
Medium rare.
When you're all wishing you were dead at the end. There's one last question, and again, I'm not sure if it's, I want to ask it, and then if we need to redirect it, at least we can provide some advice there. How can an estate be closed and a clearance certificate be obtained if there is still a balance outstanding as part of a life lease owed to the original parent?
So life, I'm assuming, well, I did have a quick read of that, and my
Mhm.
first thought was it was a life estate.
Okay.
But if it's a life lease, and
Oh.
Allison, have you run into these?
A life lease, you would think that would end on,
I think this is, I won't name the seniors home company, but
oh, that,
I
yeah,
think this is,
thinking about, oh no,
yeah, where they have money still in a life lease and the company's unable to pay the money back.
right.
Um,
I would actually maybe talk to the accountant of see if there was a way that whatever is received could be somehow put on the beneficiary's income tax return so that they receive it and pay the tax. But that is something that they would need to maybe talk to the accountant about, that it could just be everyone could agree that they would be responsible for that. Whoever the lawyer is administering the estate could put something in the release to state that they are responsible for their share of the taxes once the life lease is paid out.
yeah,
Potentially.
I mean, essentially it's a debt owed to the estate. I suppose you could distribute that debt to the beneficiaries so that the beneficiaries receive it once received, right?
Then
Uh,
the company might have to change some documents if they don't potentially.
yeah, I mean, truthfully, Lisa, that's a pretty specific question for this forum, but I think it's probably a question better. We sound bad saying you should ask the accountant. You should ask the accountant's going to say you should ask a lawyer. But
Yes, maybe that could be transferred, but it's just agreeing that all the parties would work together, or that it's transferred to the personal representative on the condition that once it's been paid out and taxes paid, that they distribute something. I'm I think Mike and I are of the opinions that the practical answer is usually one to go with, but it really
Mhm.
depends on how the parties get along too.
Fair enough. Okay, so to summarize, I think today, here's my takeaways. You should have an estate plan. Be a proponent of proactive estate planning.
um, no,
And it should be revised every 3 to 5 years. Filed in a safe place, not under the couch cushion. And tell your family, obviously, where to find it. Involve them in your planning. A plan is better than no plan, essentially. And yeah, seek some advice. Like it's not one-stop shop. Every family is different, every situation is different. So that's where your professional advice comes in. And I feel like we should have a Spotify playlist to go along with this presentation. So maybe for next time we'll plan for that. But on behalf of ECF, I just want to thank you both for your commitment to Wills Week over the years and this year as well. This has been fantastic. I want to thank everybody who attended today. I hope you found it as enjoyable and as informative as I did. As I said, this presentation and all of the online presentations will be available on our website in a couple of weeks, ecfoundation.org. Please have a look out for that. You should get a link to or a pop-up with the the survey. As I said, it is valuable. Your feedback is incredibly valuable. We are at the end of Wills Week. There's one more presentation today, but do go on the website. Feel free to reach out to myself or Mike or Allison or any of our presenters from the 13 sessions this week. And that's about it. Thank you so much. Thank you both.
Lisa,
Thank you.
thanks so much for the opportunity. We really enjoy doing this, and we really value what the ECF does for our city, for our province, and we encourage people to go and look at your website and consider the Community Foundation for their charitable giving. It's just such a great vehicle to accomplish so many opportunities for charitable giving.
Yes, and they know of so many great charitable organizations that we do not know about, and they make sure that the money is given to the appropriate organizations in accordance with your wishes. So
Okay, Allison, who's getting hold of Graceland, you or me?
you can.
Oh, I
Okay,
highly recommend it. I was there last year and I highly recommend it.
awesome. You got a
So
plan.
next year's
You got a plan.
presentation live from the jungle room.
Perfect.
All right. Thank you so much again. Have a happy Friday and a happy Thanksgiving.